Good morning. You may be seated. We are here on our case number 1CA-CV150337, Lipsky versus Safety National Casualty Corporation et al. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. You're in charge of keeping track of your own time, if you do. We record these proceedings, so when you approach the podium, we'd be grateful to you if you would give us your name and the name of the clients that you are representing. We have studied the record at some length. We've reviewed the briefs and we've discussed the case in our conference this morning. So with that, Mr. Young.
May it please the Court, my name is Taylor Young, and I am here on behalf of the plaintiff appellant Jeffrey Lipsky. We're here on appeal of a summary judgment on Mr. Lipsky's bad faith claim against his workers' compensation carrier and their adjuster. We're also here on appeal from summary judgment on Mr. Lipsky's claim for wrongful termination against his former employer. In both instances, as I think our briefing shows, the trial court erred in granting summary judgment because there are genuine issues of material fact that need to be resolved by the jury. I'd like to start with our bad faith claim and then proceed to the wrongful termination. I'd also like to, I'm going to attempt to reserve 5 minutes for rebuttal. We'll see how that goes. But I know that the court has reviewed the briefs and studied the record. I think it is worthwhile on the bad faith claim in particular to review the underlying facts, the facts which show that there is a genuine issue of material facts, to understand the chronology of what happened in this case. Mr. Lipsky,
what's the best fact in terms of showing the bad faith? You have an injury, he's assessed, he goes back to work with limited, there's more problem, and at some point in time, the carrier says no, or at least denies his request. There's a hearing, and eventually he gets the relief through the ICA that he's requesting. Where's the operative material fact dispute?
Yeah,
well,
McLean recommends surgery. The authorized surgeon, McLean, recommends surgery.
correct.
The carrier denies authorization, sends it to an IME who concludes that, like McLean did, that it's a work-related injury. Is it that initial denial pending the IME? Is it the delay that follows? Is it the sitting there saying it was the prior injury?
I mean, the answer, of course, is it's all of these things. But we can progress. I think a jury would consider all of those circumstances.
But I mean, every claim takes time. Is there a point at which the time is just too much?
Of course, Your Honor. And the issue here is, and I think we should back up. But one of the critical issue in that initial determination in February to deny the surgical benefits is that is done without any consideration of Dr. McLean's opinion whatsoever. What the adjuster said was, I would deny and send out for an IME no matter what. There's no doctor who could tell me anything that would not result in me sending this out for an IME.
But then they get the IME.
No, they do the IME, but that is itself not good faith investigation. You have to at least consider what is being submitted to you as an adjuster if you're going to give equal consideration to your insured. We're not saying, and the other side sort of seems to suggest that we're saying that somehow it's bad faith to order an IME. We're not saying that. We're saying that, and our expert said, that to order an IME without even considering the medical records. It was just a flat denial. And really, what this denial is based on is a person with no medical training or background making the decision that back doesn't equal neck.
Okay, so what is the denial, the reiterated denial after receipt of the IME based on?
Okay, so the reiterated denial is based on this notion that there is that there's this other injury, there's this other claim, it could be pre-existing injury, and that is a reason to deny surgical benefits. And then later we hear that it's actually in litigation, and therefore we're going to deny. And I think this is an important point. I just like to read. Apologies.
While you're getting that, as a matter of law, is it ever a permissible ground for a carrier to deny coverage on the theory that the injury exacerbated a prior injury? Is it ever permissible?
For a carrier to deny based on an exacerbation? I don't think a denial based on exacerbation is permitted under the Tatman case and subsequent authority. It says that that's covered. Now, we have a statute, and in fact, it was involved in this case. It comes later in the chronology, but in July, the ICA orders payment from safety, says you got to pay these benefits, and that is when you have an issue between two possible different carriers, two possible different injuries. The statute says that you can ask for a determination, and the ICA can order payment of benefits.
Right.
That happened here, and they didn't pay the benefits, by the way. They didn't pay the benefits until October. And by the way, during which time my client is not getting surgery that he was needed and was reasonably had benefits to back in February. But let me turn really quickly, and this goes to some of the facts that I was going to mention, and this is in our appendix, and I'm looking specifically at page 102 of our appendix, and this is that question about when the subsequent denial happened, what was the basis? Here's a question by counsel to the adjuster. In your capacity as the adjuster on the Lipsky file, is it your opinion that as of Dr. Began's report, the cervical spine surgery was necessary because of workplace injury? The adjuster answers yes.
And that's in March.
That's in March, March 15th. Okay, so did Gallagher-Bassett then accept the claim and authorize the surgery? Answer is no. We were currently in that litigation, which is in litigation about who is...
What litigation was that?
I believe the reference is the litigation to the claim, the 2001 claim, the reopening of the 2001 claim. And that's the basis. So we did not proceed with any surgery. This is the adjuster. So we did not proceed with any surgery at the time, determining where the judge was going to put the claim at.
What I'm asking, Mr. Young, is was there in fact a litigation as of March 15th?
Had the 2001 claim been petitioned to be reopened is the question. And I believe that the 2001 claim was petitioned to be reopened. As of that time, that's what the litigation would have been referring to. And also, Mr. Lipsky was represented by counsel at that point as well. I'm pointing to, this is page 104 of the appendix. Again, question, do you have any obligations to follow what both a treating physician and Dr. Began recommended here? Answer, yes. You didn't do that, did you? Answer, not at that time, no. So we have an acknowledgement, a frank acknowledgement from the adjuster that they knew that this claim was compensable. They knew that this benefit was owed, but that they were not going to authorize the surgery at that time. That's the second denial. They're essentially, and this is just zilch language, right? They're requiring my client to jump through all of these hoops in order to receive the benefits to which he's entitled. And that's classic definition of bad faith.
What if the delay had only been 3 months? Would that be bad faith?
I think under these circumstances it could be if you have a decision. Again, this is a question about whether or not there's a reasonable basis. If you have an adjuster with no medical training, and I point the court to the Demetri Ellis's case, Temple case, I'm sure you've read them. If you have an adjuster with no medical training who is making a determination to deny these benefits without any basis at all, not looking at any of the records, just saying, no, I'm going to make you jump through this hoop automatically.
So I take it that your bad faith claim is, to summarize, is kind of based on one example of bad faith would be the kind of knee-jerk reaction by the adjuster. I'm not going to agree with McLean. I'm going to get an IME. And then second, after the IME was obtained, I'm not going to approve the claim because there's a dispute between whether we have to pay for it or the prior carrier has to pay for it.
Correct. Those are both, okay. I would say, those are both pretextual. These are jumps. These are hoops that we're being made to jump through. And then we also have, simultaneous with this, the adjuster then launches an investigation over the summer into some claim that my client was malingering based on what a neighbor said. And that stretches the proceedings out because the ICA proceedings get continued essentially to allow for Gallagher Bassett to conclude its investigation into fraud. And so we have, I think we have ample evidence from which a jury could determine that there was no reasonable basis objectively, and that subjectively, again, based on the adjuster's comments, that she knew that she was supposed to give them benefits but did not. That's conscious disregard, and that's enough under our bad faith rules. I think the court is probably well aware, although we see it a lot at the trial court, of language hitting the highest sort of punitive damages standard as if that's the standard for intentionality under bad faith, and it's not.
On the claim against the employer.
Yes, ma'am.
As a matter of law, does an employer have to keep an injured employee on the books forever if he's injured on the job?
I don't think so, and I don't think that's the consequence of what we're saying in our claim. The question here is, have we submitted, again, this is summary judgment, have we, and there's a lot of flipping the burden onto us as if it's our obligation to establish that as a matter of law they can't do X, Y, or Z. That's not our obligation. Our obligation could a jury conclude that there's a causal nexus? And here I think getting past the fight between the parties about whether it's the filing of the claim or whether there's other protected activity, I appreciate the court's, you never know, the parties can't stipulate to the law. But in terms of the nexus here, we've presented enough evidence that establishes, from which a jury could conclude that there was a causal retaliatory nexus here. The employer was aware of the claim, the timing of the employer's notice that you're on 14 days was triggered immediately upon Dr. McLean's letter coming into the workers' compensation carrier. We have the.
Is the employer entitled to rely on the considered judgment of the claims administrator, Gallagher, which on February 23rd said not covered?
I don't think so in terms of, if you look at, for example, the Grab case that we cited to you, which of course is not an Arizona authority, but I think it's persuasive. What the court discusses there is you're not allowed to choose which doctor you want to believe in order to, or let me put it to you differently. Perhaps you can choose, but you are at the risk of a wrongful termination claim if the jury disagrees with you, right? So we think that we had Dr. McLean, who clearly said it's related. You have a claims administrator who says no, but that I don't think is inoculation against a wrongful termination claim. I see I only have 1 minute left if I want to reserve time. I did want to point out something else that in response to the argument that this is a neutral employment policy. The record establishes that, in fact, it wasn't applied neutrally. What in fact happened is that the employer said it would be applied on a case-by-case basis depending on what the reason was that the employee was missing this time. So even if the employee wasn't eligible to fall outside of this neutral policy, some employees apparently could, based on the reason that they were giving. And I think what that suggests is that you really do have an employer here who is investigating the underlying reason and deciding that Mr. Lipsky, that it's not going to believe Mr. Lipsky's doctor and it's going to prefer its own, or prefer the opinion of its claims adjuster.
Well, but couldn't the employer say, we called you and you said, I won't talk to you, we wrote you, we got no response, and so isn't it reasonable that you've been gone for this point in time, that we terminate your employment without worrying about a wrongful termination?
But he'd already requested a hearing on his workers' compensation claim, and they were on notice that his doctor had advised him not to return to work, and their response was, so what? You're not entitled to benefits.
There's no evidence the employer knew that Dr. McLean said this was a work-related injury. Is that right?
I don't think that's true. I think that what the employer knew at the time was that he had that he had been seen by the doctor. The doctor had recommended surgery.
And directed him not to work.
And directed him not to return to work.
But
I don't think that they. I don't. I'll try and have an answer for you by the time I get back to my 4 minutes, Judge Thompson. I want to make sure I understand.
I recall the employer was not informed specifically by whatever they saw from McLean that McLean's opinion was that it was work-related.
I mean, McLean's opinion is clearly set forth in his letter that it is work-related. So,
but it's not clear that O'Reilly handled that.
I hear what the court is asking.
Okay. Very good. Thank you.
Okay. Thank you.
Good morning, and may it please the court. My name is Deanne Ayers, and I represent Safety, Gallagher, and Ms. Powell. Ms. Pate and I, counsel for O'Reilly, have agreed to a division of the time, 15-5. Of course, if I have any left, I would respectfully yield that back to Ms. Pate if I go under my time. At the outset of the argument, Your Honors, I would submit to you that there is a variance between the briefing on appeal and the actual summary judgment record that the trial court had before it. There are assumptions that are made in briefing that are simply absent from the record. And following up on a question that was asked to counsel in his initial presentation about a second denial, there was no second denial. In the record before the trial court, there is no evidence that there was ever a second denial of this claim.
Well, let's talk about that then. The ground for the initial denial was we need an IME. The IME was done within a matter of weeks, and still the carrier failed to pay. What was the ground on which the carrier decided not to pay?
It was essentially an extent of injury dispute because a notice of claim status was filed actually accepting the injury. So we were looking at an extent of injury. And the extent of injury was that a statement was taken from Mr. Lipsky, and an index came back from the Bureau reflecting that while employed at Lowe's, Mr. Lipsky had had a serious cervical injury for which he had been unemployed for years that resulted in surgery.
As a matter of law, in Arizona, does that entitle the carrier not to pay? Isn't the law to the contrary?
It can entitle them, and this is how, Your Honor. the burden of proof at the ICA level is on the worker to establish that if he is claiming an aggravation of a pre-existing injury, the worker bears the burden of proof to establish that there has been an organic change to the complex of the structure of the body, has the burden of proof to show that it is not a temporary condition, and has the burden of proof to show that the condition he's now claiming is work-related is not a natural progression of the original injury.
Did anything in the IMEs reflect that?
Yes, Your Honor. In the record, what Dr. Bagan says is, and I would quote from this, is this would not have occurred but for the prior surgery. But for, and I think there's a typo, it says, but for, without here, the prior injury, there would not be this current injury/surgery need. So that's in Dr. Bagan's report that's in the summary judgment record if you read it in its totality. And what we know was that the very week that Dr. Bagan's report comes in, Mr. Lipsky files a notification with ICA seeking a petition to reopen his claim from Lowe's. He didn't plead it in the alternative. He didn't say it's one or the other of these carriers, please sort out which one it is. Instead, he filed and attested to a document before a state administrative agency that said specifically, applicant has sustained a new, additional, or previously undiscovered condition causally related to the industrial injury of January 22, 2001. So the very week, and this was April, the end of April 2012, that the IME report came back to the adjuster, and it was the end of April, the same week that Mr. Lipsky made this filing with the state agency. At that point in time, the carrier has noticed that Dr. Bagan's report can be reflected and can be read to reflect that it is a continuation of the prior claim, and she knows that Mr. Lipsky himself has filed with an administrative agency a statement saying, I want to reopen my prior claim because I have a condition related to my prior claim. And she also knew at that point in time, this was the second time he had moved to reopen that prior claim. The first time he had had it successfully reopened and had had additional surgery, additional procedures for the cervical and additional lost time. So at this point at the end of April, the adjuster knows all these facts. And she also knows that a hearing has been requested by the appellee to determine, does he have a new injury? Does he not have a new injury? Does he have an injury that either one of the carriers is obligated to pay? I mean, it's quite possible he could have had something that ICA would have found neither of the carriers responsible
No
for.
basis in any of the medical records in April to support that proposition. It was a matter of somebody was going to have to pay.
I think that's fair, Judge Johnson. I think it was. And I think the question was ICA going to find that there was an organic change or that it was a continuation? And in fact, what the ICA judge held was that there was a dispute in the medical records. So the ICA judge in the report didn't say the medical records are identical, they're the same. The judge noted that there was a difference of opinion in the medical records, but chose to adopt that it would be the latter injury, that it would be safety's injury that would pay. And of note, I would also point out, Judge Johnson, that at no time after the February position on extent of injury that was taken by safety, at no point did Dr. McLean or the appellee come back and re-urge a request for surgery. At no time did that happen. So, and that was my point earlier, that there was no second denial. There was not a circumstance where ICA said, we're going to make a determination that during the pendency of this decision, one or the other is going to pay, and then a request was made for approval and denied. That did not happen in this case. And in fact, what is in the summary judgment briefing before the trial court was on page 11 of that brief, the workers' compensation attorney said that he wasn't even aware that there had been any determination as to who should pay during the pendency until October 5th. Well, that was at the time setting that they were actually issuing the final award on the case. And after the final award was issued, there was a request for pre-authorization of the surgery. It was pre-authorized, and he did have the procedure.
Is there a process in the workers' comp system by which, in a case like this, where it's clear the worker sustained an injury and one or the other of two carriers is going to have to pay, the two carriers can sort it out, and in the meantime, the guy can have the surgery?
Absent an order, no, there's no right to reimbursement unless the companies have an intercorporate arbitration agreement between the two that would indicate that if one carrier pays, they will have a right to go to arbitration to get reimbursed from the other carrier. So the remedy is to actually get an order with a surgical date and a surgical consult to come in and say, Company X is going to pay for this. And in this particular case, I'm
Tell
sorry.
me that again. What's the remedy?
The doctor submits medical records, and the claimant's attorney, which there was an attorney from before the denial in this case, and they request an order specifically seeking the authorization of a surgical procedure. That can be done.
Request an order from the ICA.
ICA, and that can be done. And in this case, there was some discussion about which carrier would pay during the pendency. And after that happened, there was never a request for care submitted back on the claim. And this is my point, that the attorney for the appellee said, well, I wasn't even aware that that had happened. So if he wasn't even aware that there was a potential remedy that this could be utilized or could be done, it's indicative of the fact that it wasn't done. So there was no second denial. There was no time when anyone came back to safety or the adjuster and said, look, during the pendency of this dispute that I myself have filed by invoking both cases, you should pay this. That didn't happen. There was never a second request for surgery. There was never a presentation of a J order to Safety or Gallagher or Ms. Powell with a specific surgical procedure and a demand that they pay it, and then they rejected that. That is not in the record before this court or before the trial court when determining summary judgment.
Well, but there is the continued denial, that the continued refrain from paying after receipt of the IME that pretty much showed that it was a workplace injury at O'Reilly.
Well, and again, I believe that is the dispute with Dr. Began's IME report. There was an issue with regard to whether or not it was a continuation of the prior claim, because his exact language is that but for the prior surgery, but for the prior injury, there would not be the current need for surgery in this situation. And that was where the ICA discussed the fact that there was the conflicting medical and chose to adopt Dr. McLean's view. And so the question isn't, though, Judge Johnson, was the adjuster right? That's not the question, because perfection and being correct is not the test in bad faith in Arizona. Right. It's was it reasonable? And in this instance, it was reasonable, the record bears out, and not just for the IME, but there were multiple reasons why it was reasonable to take an issue that the extent of injury to the cervical was not related to the O'Reilly accident. And these are the reasons that it was reasonable. One, the claim came in and it was reported as a lumbar spine. It was accepted for benefits. Benefits were paid. This is not a circumstance where safety said we're not going to pay anything. Benefits were paid. It was after that time period that suddenly the appellee said, now I want to extend my lumbar claim to a cervical claim. We also have the circumstance where we know that we have an individual who alleges to be a neighbor of appellee come in and say facts that might raise a red flag. Is this or is this not a fraudulent claim?
How long did that take to investigate?
There was not a there's no evidence in the record there was a continuance because of that. That was ongoing. And the report to the record is devoid as to when this information was provided to O'Reilly. It was provided to the adjuster on March 24th of 2012. And at that point in time, the adjuster began investigating, is he a habitual claim filer? Is this a fake injury? Is this real? That part of the investigation, which they're entitled to do to see if it's a legitimate claim before benefits are paid.
What does the record say about how long that took?
What the record says about how long that took was that it took about 2.5 months with a private investigator going out, talking to neighbors, and still getting records. Because due to the fact, up until the time that the ICA proceedings were joined as one, up until that point in time, Ms. Powell could not get the records from the Lowe's injury. And so she had to send medical authorizations and go through a formalized process to get records and see what was there. And she was doing that.
Did she ask Lipsky's lawyer for those records?
Yes, the record reflects that there was a request for medical authorization sent, and at some point in time in May, the authorization was sent back to the adjuster. But by then, they had joined as a party to this ICA combined proceeding, if you will, and so the attorney for safety was able to get them through that process. So by the time they got the authorization, they were able to already be using the process to get them. And so, again, and I certainly don't want to step on O'Reilly's counsel's time. Again, what the record reflects is that there were multiple reasons and there were multiple justifications for an investigation, for an IME, which is appropriate under statute, and for a denial of the extent of injury on this case. And the appropriate thing was done, which was once the appellee said, it's the other claim, the adjuster was entitled to rely on that and believe that that was true and believe that he wouldn't be making a misrepresentation.
Well,
He
the
didn't
appellee
plead
didn't say that until you denied it because it was the other claim, and then the appellee then was in the position of, I need to have the surgery. I'm going to do what I need to do.
Oh, but he didn't do it when they denied it. He did it after the IME report came back because
Well,
the IME
but
report.
you didn't pay then.
Because because the IME report said, but for the other claim. And that's the distinction, that at that point in time there was a reasonable basis that the other claim caused the continuation.
Under Arizona law, doesn't a workers' comp carrier take a worker as it finds him, like the eggshell plaintiff rule? You're stuck with a guy who has this injury, a prior injury, if he exacerbates the injury, aren't you?
That's the test. It has to show an exacerbation, and it cannot be temporary.
But
It
isn't
has
that what your IME said?
No, he said but for. That he had the burden of proof is on the worker to show a change in the organic structure. He is under an obligation at ICA level to show that this is not the natural progression of his already existing illness, his otherwise existing problem. And that's where the horse race comes in of which doctor should the adjuster follow. And in here, what happened was the process was followed at ICA, where the ICA judge weighed the competing evidence and said, we're going to go this way instead of the other. With regard, just in 24 seconds, with regard to the aiding and abetting claim, Arizona law is clear that there had to have been some tort of safety to be aided and abetted by Powell and Gallagher. That didn't happen here. There's no evidence in the record that occurred here.
Isn't safety liable for the conduct of its agents, though, Gallagher and Powell?
But that's a different
Right,
element.
but it is. And
Yes, vicarious liability might
Right.
possibly be an issue for an insurance company, but then it's a secondary liability when you look at aiding and abetting.
Yeah.
And so the principal's conduct isn't automatically imputed to the agent. There has to be knowledge, and there has to be an assistance of the agent, and the agent has to actually be assisting someone besides itself. Thank you.
But you don't challenge the agency relation, right?
No, Judge Thompson, we do not.
And Powell and Gallagher are liable for their own acts, separate and apart from any aiding and abetting claim.
Well, they would be had it been pled, but the only allegation against them is the aiding and abetting claim.
Okay.
Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Melanie Pate. I'm with the firm of Lewis, Roca, Rothgerber, Christie. I represent the appellee O'Reilly Auto Parts in this matter. The trial court's grant of summary judgment in this matter was entirely appropriate. Mr. Lipsky was terminated pursuant to O'Reilly's neutrally applied attendance policy. He was not retaliated against in any way for exercising his rights under the workers' compensation statute. Yes.
Since we just have a couple of minutes,
Yes.
let me get to the point. O'Reilly saw a record from Mr. Lipsky's authorized surgeon, McLean, saying he needs to be off work for 6 weeks. How is it legal as a matter of law, for O'Reilly to fire him under that circumstance,
Especially when they
consistent
knew-
with this policy.
And they knew there was a workers' comp claim.
They had known since January that there was a workers' comp
They
claim.
knew that Lipsky was asserting that this was a work-related injury.
Oh, absolutely. Yes. And after he filed his workers' compensation claim in January, early January, they kept him at work with work restrictions for the following 2 months. They gave him a satisfactory performance evaluation. He successfully completed his job training period.
That's not an issue. What's
Yeah.
at issue is when they fired him.
They fired him. Yeah, they fired him because he was not eligible for leave under any of O'Reilly's leave policies, nor was he eligible for Family and Medical Leave Act leave
But he
because of the
would-
short period of time that he
Why
worked.
wasn't he eligible under the O'Reilly workers' comp policy?
Because the carrier, their third-party claims administrator, had denied his claim based on the neck pain. And the neck pain was the reason why he needed to be off work for 4 to 6 weeks. So O'Reilly reasonably relied on the determination that they received from their third-party administrator.
Turned out
They
to be
took
wrong,
that-
didn't it?
It did. 7 months later, it turned out that the ICA did make a different decision. But the information that O'Reilly had in its hands when it made the decision to terminate Mr. Lipsky was that his workers' compensation claim related to his neck pain, which was the reason that he needed to be off work, had been denied by the carrier.
Right, but what the employer knew was the claimant said it was a work-related injury. Gallagher said it wasn't, and they chose Gallagher, and that they ended up being not correct.
And O'Reilly absolutely has a right to rely on the information that it receives from its third-party administrator, telling it, look, this person is, as of right now, is not eligible for workers' compensation benefits. We have denied his claim. And so therefore, he was not eligible for additional leave for a medically related reason under O'Reilly's workers' compensation leave policy. And on the same, oh, sorry, go
There's
ahead.
no evidence, or is there evidence that O'Reilly had a conversation with anyone at Gallagher about to inquire, what's the basis for your denial? If it had, it would have found out that the basis for the denial at that time was that Gallagher said it needed an IME.
No, there is no evidence in the record that the decision maker, who was their leave administrator, that she had any conversation with anyone at Gallagher about the specific underlying reasons for their determination. In fact, O'Reilly has a separate person who is in charge of, interfacing with the carrier. And so, what the information that the leave,
So O'Reilly has silos.
yes, they have.
Information may not be transmuted, and you end up getting stuck with whatever the results are.
Exactly, Your Honor. And so they applied their neutral attendance policy. And the thing is that they were trying to communicate with Mr. Lipsky. They called him. They sent him a letter. They specifically
All they
said
needed
to
to do
him,
was communicate with Gallagher and find out the McLean's report said it was work-related.
but they were entitled to rely on the determination of their carrier. They are not
But couldn't they find out
self-insured.
what it was
Is there
based
a
on?
case that says that?
There is no case in Arizona that specifically says that, but there's also no case that says that they cannot rely on the determination of their third-party administrator. And it
Maybe
is
what
not.
we have a jury for.
It is not illegal in Arizona, and this is an important point. It's not illegal in Arizona to terminate a person who has, who is receiving workers' compensation benefits just because they need to be out on leave. Their job is not protected under Arizona law.
But under and this may be a situation where the employer is penalized for being a good citizen, under the O'Reilly policy, if Gallagher had told O'Reilly on February 23rd, this is compensable, O'Reilly would not have terminated him, right?
No, he would have been eligible for
Yeah,
leave
that's
under
the
their
thing.
workers' compensation policy.
Okay,
It's
we're
undisputed.
kind of beyond our.
I'm sorry. I'm out of time. Thank you.
I have just a couple of quick points that I'd like to respond to that last discussion first.
Well, you seem to have posited the idea with regard to the employers that O'Reilly was on notice, not that they necessarily knew that the doctor was saying that this was a work-related injury, but that they were on some sort of inquiry notice.
Well, I think they have to be bound by their third-party administrator. I mean, the discussion that O'Reilly's not self-insured, so, hey, they're not bound. They're not culpable for what their third-party administrator knows, or that they are entitled to rely on a third-party administrator, whereas Walmart, who's self-insured, or McDonald's is self-insured, would not be. That seems to me that creates public policy problems that probably are not intended under the statute, which allows you to pursue a wrongful termination claim if you're engaged in protected activity. And here the protected activity, I think as the court knows, is pursuing workers' compensation benefits. So I think O'Reilly is on, at a minimum, inquiry notice, but possibly is just bound by its third-party administrator's erroneous, bad faith, in our view, decision. And we think the jury will agree with us on that.
Why should Gallagher and Safety be liable for punitive damages if, after the receipt of the IME, there was a question of fact about what the organic cause of the injury was?
Well, the organic cause, whether there was a question of fact about organic cause, that appears nowhere in the trial court record. This emerged in fully on appeal. This discussion of organic change and the burden being.
The point is that you had the burden of showing that is what
was
being urged.
There is a
once they knew about the prior surgery and its complicity in the current problems, that they could wait to see what you.
But I don't think they can wait. I mean, there is and this is, I think Judge Johnson brought it up, the reason why we filed to reopen that claim was to try and get the surgery to which we're entitled. We're entitled to these benefits. The fact that there's some dispute over whether it's going to be compensable from one carrier versus the other doesn't change the fact that we're entitled to those benefits, and they aren't entitled to, they're not allowed to put their own interests over ours. So their obligation was to provide us with the benefits, and then if the claim, in fact, what should have been paid under the 2001 claim, then they could go against that carrier and have an adjustment, and that's what that Section K provision provides.
And that's part of the statute?
The section, the subsection K of the statute allows for that type of order to be requested.
Was the order requested?
It was, and there was and the order was issued. Let me point the court, just because we don't have any time. I wanted to point the court to the deposition transcript pages on that. I apologize.
Well, who was it? Who was the deponent?
I'm sorry?
Who was the deponent? We'll find it.
Oh, it wasn't a deponent. It was it's attached to it's a transcript from the ICA hearing where the ICA judge says, I ordered this to be paid. I can give you the citation. It's in our brief. I see that I'm out of time.
Any further questions?
Yeah, just real quickly, if you had not shown an organic change, that it turned out that your guy couldn't go back to work because he had a valid workers' comp claim against the prior claim, but he couldn't work because the doctor told him to, then O'Reilly could fire him?
Well, I don't necessarily agree that the organic change is the actual standard. There's one case that discusses that. It's after the Tatman case and isn't repeated again in the 1995 case, which citation is slipping me right now. So I think that Arizona law says that if it's a pre-existing condition and it's been aggravated, it's compensable. I think this organic change was a discussion back in 1970 some odd, which has not survived to this date. But the court can read those opinions and I'm sure come to some conclusion on that.
Thank you.
Thank you.
Okay. Thanks to all the lawyers for your briefing and your argument. We will take the matter under advisement, issue a decision in due course. Now we stand adjourned.